If anyone wants to give us like written comments, they can do that. They can send them to us by email. Okay. All right. So I'm going to go ahead and get started here because it is a little after 9:30. So I'm going to make some opening remarks, and then we'll open up the floor to comments. But just go ahead and get started for the record here. So good morning, ladies and gentlemen. For those of you who don't know me, my name is Jason Nelson, and I am the Executive Director of the Office of Public and Professional Guardians, and I'm going to be presiding at this rule workshop today. For the record, this rule workshop is being held in room 301 at 4040 Esplanade Way in Tallahassee, Florida on Wednesday, April 20th, 2016 at 9:30 a.m. pursuant to notice thereof. As you know, the subject of this rule workshop is to discuss the Department of Elder Affairs oversight of professional guardians and rulemaking that will need to occur to implement statutory changes to Part 1 and 2 of Chapter 744 of Florida statutes. Copies of the agenda are available to anyone present who does not have a copy. If you need a copy, please come forward to get one. This hearing is being held because it was properly requested within the purview of the Administrative Procedures Act. The Department of Elder Affairs instituted rulemaking proceedings for this rule pursuant to Section 120.54 of the Florida statutes by publication in the Florida Administrative Register in Volume 42, number 67, which was published on April 6, 2016. The specific purpose of this hearing is to give affected persons an opportunity to present evidence and argument on all issues under consideration, to inform the department on its contentions as provided in Section 120.54 of the Florida statutes.
Communication mode is now enabled.
Great. Okay. I will initially, and just so you know how we're gonna handle this rule workshop today, I'm gonna initially open the floor to discussion concerning standards of practice for professional guardians. And in order to help guide that discussion, I'm going to present a number of topics that the department is currently considering in terms of professional standards and general topics of discussion. And this is not necessarily to limit the discussion, it's to kind of guide it. And then after we've gone through some of the topics that I present here, if anyone else wants to raise issues concerning standards of practice, they're more than welcome to do that if we haven't already discussed it. And then we're going to move on to address disciplinary guidelines for professional guardians when a standard of practice is violated. And that will also include any mitigating or aggravating circumstances that could be relevant to the disciplinary guidelines. And then lastly, we'll open up the floor to discussion of any other matters that people want to talk about. So just to give you a little more information, everyone in the room and on the phone will be given an opportunity to speak. But we do ask that when you are given an opportunity to speak, that you please identify yourself by name and title or capacity in which you speak. And also, we ask that you speak loudly enough so everyone can hear. Constructive suggestions and proposed language is strongly encouraged, but please do avoid redundant or cumulative comments. These proceedings are being recorded, and they will become part of the record of this rule workshop. Therefore, as I said already, please identify yourself each time that you speak, and only one person at a time will be allowed to speak. The record will also include the notices, the agenda, all written statements, petitions, and requests, and all evidence presented to the department. So at this point, I'm going to open up the floor to hear comments regarding standards of practice, and specifically, I thought we would start off by talking about standards of practice for professional guardians related to their relationship with wards. Is there anyone who'd like to weigh in on that particular topic? Sir?
Alan Saylor from St. Petersburg. I'm a citizen of Florida.
Okay.
I assume that perhaps part of what you're looking at is from the National Guardianship Association Model Code of Ethics for Guardians.
Okay.
And then I assume that's where this
Yeah, that's where some of these topics have come from, but this rule workshop is not limited to anything that's, in that document. I don't know whose microphone that is, but.
That's mine.
Yeah, so the rule workshop is not limited to anything that's in that particular document, so we're interested in receiving comments from the public, and like I said, not limited at all to that document, but some of these specific topics were taken from that document, yes.
I would like to point out that there's some very good information that's included in there, and some of the things which, on this current copy, I'm looking at page 12, page 13, and page 14.
Mm-hmm.
And I think these are very, very important issues, and that some of the things that I've seen where there's been issues with the guardian's actions in relation to the ward. One of the first things is under their Rule 3 that the guardian shall ensure the ward resides in the least restrictive environment available.
Mm-hmm.
And item 3.4 under that, the guardian shall not remove the ward from his or her home or separate the ward from family and friends unless such removal is necessary to prevent substantial harm. The guardian shall make every reasonable effort to ensure the ward resides at home or in a community setting. Some of the things that I've seen is that that's been completely disregarded, and the ward is restricted with family visitation, removed from the home when it wasn't necessary, and it was more for the convenience of the guardian. So I would say that that's a very, very important issue that needs to be included in this.
Okay, well, we'll certainly take that under consideration. And also just let everyone know, maybe I should explain a little bit about the rulemaking process. So we are currently in the initial phases of the rulemaking process, which is known as we've actually just published a notice of rule development. And we're currently holding right now a rule workshop. And this is an opportunity for the public to give input on how they think that the rules that we're currently in the process of drafting should read. And at some point in the next month or so, or a few months, we will we may hold another rule workshop. We haven't really decided, but after that, we will publish a notice of what's called the notice of proposed rule, and that actually will be we'll actually publish the text of the rules that we're planning on adopting, and then that'll be an opportunity for people to give specific feedback on that text. So we're really kind of just in the informational gathering phase of the rulemaking process, and then the next step, once we have all the relevant information, we'll be drafting a proposed rule, and then the public will have an opportunity to weigh in on that specific the text of the rule. So that's just a little bit of background on where we are. So someone else has comments?
My name is Lynn Saylor. I'm from St. Pete. I represent myself, OPPG, and
Okay.
NASCA. I wanted to refer again to this, in that these rules, when they're completed, will they be part of the statute, Florida statute?
No, they'll be part of what's called the Florida Administrative Code. So the statutes, the Florida statutes consist of laws that were passed by the legislature, and then the executive agencies create what are called administrative rules that are designed in part to implement the statutes. And so the rules that we are developing, they'll be contained in the Florida Administrative Code.
Okay, so they will have to be followed. They will be enforced.
Yes, yes. Mm-hmm.
Well, our experience with this is we were in court and brought this up to attorneys and the judge, and they said these were not laws. They didn't have to abide by these.
That's correct.
Okay.
Yeah. So those are, I believe, what you're holding there are model standards of conduct. So they're kind of like recommended standards of conduct. But the standards of conduct, or the standards of practice, as they're referred to in Senate Bill 232, would be mandatory standards that would have to be followed by anyone who meets the definition of being a professional guardian. And if it is determined that they are not being followed, then there would be disciplinary actions that would be taken against them.
Thank you.
Sir?
Hello, my name is Doug Franks. I'm from Pensacola, Florida. I represent Ernestine Franks, my mom, 94-year-old native of Pensacola, Florida. I grew up in Florida, but now reside in Ackworth, Georgia. My mother was put in a guardianship in 2012, and even though she had all her advanced directives, testified in court, went to neurologist in between the first and second day of court, The judges said it's the best thing. And it's the best thing because it was $1,000 a day my mother has spent to stay in her home. And when we tried to do anything, the attorneys just simply bled more and more money from the estate. And if anyone was to look and see what did Doug Franks do wrong, he tried to get his mom out of guardianship. We have no ability, once you're in guardianship, that's it. Because for-profit guardianship really is, the worst scenario is, I'm accumulating humans for profit. And I don't want to let those humans go because I'll lose the money. And so it kind of, I know in some cases, I'm sure it's a fantastic thing and it must be had, but right now with OPPG, a group I also represent, there's members in our state of Florida, but also around the country, that simply, this story is the same. It repeats itself. And again, all the children and all the family members are all crazy because they have to be painted as the bad people to continue this stage litigation. And again, it just seems like the most expensive cases are the people that have the most money. So that's rules need to be put in place that judges have to really follow instead of just using their discretion. And we've all seen it. It's just simply, it's a good buddy system.
Okay, and just to clarify, so you're aware that these standards of practice that we're developing, they don't apply to judges. What they apply to is the professional guardians and how they conduct themselves in relation to the wards that they are serving. So like I said, just so you're aware, I mean, so like I said, I just wanted to make that one clarification, but we do appreciate your comments and we'll take those into consideration as we move forward. So if there's no one else that has comments that they want to specifically talk about in regards to a guardian's relationship with the wards, we're going to move on to the next topic of discussion, which would be the guardian's relationship with family members and friends of the wards. If there's anyone who want to weigh in on that specific topic, please feel free to do so. Yes, ma'am.
I took that 40-hour course, Lynn Saylor. I took that course, and that course, I also was a guardian ad litem for 2.5 years and an ombudsman for 2.5 years. And the courses I had to take for that was much more extensive than taking that 40-hour course from St. Pete College in Florida. But it's, the course does not teach about culture, it does not teach about being kind, it doesn't teach about being respectful. The course teaches none of that. They come into a stranger's house who is not somebody who's totally incapacitated. They walk into their home and say, I am court appointed to be your new guardian, and I can take you out of your home today, but I'm not going to do that today, but I'm in charge here now. And it's not a very nice situation, and I think that they're not trained properly. The course is not set up to teach them to come into people's homes and to take over large amounts of money and make medical decisions for anybody. It's not a proper course for this kind of job. They make $45 an hour guaranteed plus driving time. Who gets that kind of money with a certificate? Who? I don't know anybody that does.
I'm Doug Franks, again representing Ernestine Franks, Pensacola, Florida. Just a couple weeks into the guardianship, we got a letter saying that you'll no longer be able to spend the night at your mother's home. You'll no longer be able to be with her alone. You'll no longer be able to drive her anywhere. It was a whole long list of things we would never be able to do anymore. There was really no reason except for we upset her. And that proof was from an unlicensed care service that actually was in charge for 21 months that the guardians hired, that I called ACA and we found out they were unlicensed. But the burden of proof is zero to restrict family members. And again, I'm not going to say all guardians are this way, but the bad ones can be extremely bad, and they can be detrimental to the family. My mother says, Doug, why don't you spend the night? I love my 3 boys. I should come more often. I can't tell her, no, I can only spend 3 hours here, and you just spent $300 to see me, Mom. I can't tell her that, and I wouldn't. But I want the public to know, and I want some of these cases, the atrocities that take place, to be publicized. so that the people that do it don't do it anymore, and the people that thought about doing it know better. And then the good people say, well, I never did that with my while I was in guardianship. So it's a time to stand up tall and be a good citizen, a good human being, or either be outed for what you are, a manipulator and someone that just simply destroys families for greed. And again, it is about the money, it seems like.
Okay. All right, anyone else? Oh, sir.
Alan Saylor from St. Petersburg. The relationship with family is very, very important, because these elderly people, this is some of the last tangible things that they have. And I've seen too many cases, I can think of 3 right off the top of my head, where the guardian has restricted family visitation, trying to cut off complete family visitation, all relationships, without ever offering any proof. And I heard a judge say in court, I will not second guess the guardian. So the guardians are out there just doing this on their own. They'll state, oh, it's in the best interest of the ward. And it's also to the guardian's advantage to paint family members as enemies, because what this does is generates more hours, more time on their part for the guardians and the attorneys. When family members get very, very frustrated when they've been restricted from visiting their family member, you know, sometimes maybe they were visiting 3, 4, 5 times a week, and all of a sudden, boom, they're off. Then they say, well, you got to have supervised visitation, without ever going to court, proving anything. So it's very, very important. It's important for the ward. It's important for the family members. And this is where those guardians who want to take advantage of the system really can do it, and it's to their benefit to create this conflict, because then they got more billable hours on it. So I think it's really, really important that these rules that you're working on works on strengthening or maintaining existing family relationships.
Mm-hmm. Okay. All right. We'll certainly take those comments into consideration. Is there anyone else who'd like to speak on this subject? Okay. So the next topic we're gonna move on to is the guardian's relationship with other professional service providers. Is there anyone who'd like to be heard on that subject matter? Yeah.
My name is Doug Franks. I represent Ernestine Franks and AAAPG.net. The Guardians hired a company called West Florida Home Care. Home care, not health care. There's a big difference. Home care cannot help someone get out of a chair. For 21 months, my mother had services by these people, paid $227,000 plus about $60,000 in benefits for insurance. These people were unlicensed to give her care. I found out about it through an ACA. They did an investigation. They eventually fined these people. These people also were involved with giving hydrocodone out, which is a fact, without a license that was 2 years expired. We brought this to the courts and to the guardians, and they said, the Franks boys have just been too terrible. We're going to quit because it's just been too difficult. They've made it hard for us. Not that they were unlicensed, not that my mother gained 30 pounds, not that they went out 5 days a week and ate at $21 meals for a 92-year-old woman, none of that. So we have to really watch out who is hired, and I'm sure there are kickbacks which are legal if these people are the proper license, and if they're not, then I know there is a law against that. But again, in our case, nothing was done, except for a new service, and some of the old people from the previous care service were brought in to keep the money flowing and to keep the lies going. So there's some real difficulties here with people doing things that are not licensed just to make money off the wards.
Okay. All right. Thank you, Mr. Franks, for your comments. Anyone up, ma'am?
I'll be brief. Lynn Saylor. My experience is that they will actually sometimes hire other guardians' children that are unemployed, or other guardians' friends, or even try to hire their wives or their children and pay them as professionals doing services for them. I've also experienced where they will doctor shop. If they don't like what one doctor says, they'll go to another doctor. And I've also seen where they will hold their meetings, the one in Pinellas County in particular, for free at the facilities, and then they get free meeting rooms and free food. and they bring in wards there, and I think that's kind of a little bit of a conflict of interest. Most people don't get free meeting rooms and free food, and they don't bring in 15 or 20 residents to this place where they will now be paying. There's kind of seems to be a big conflict there.
Okay, all right, thank you for your comments. Actually, that's actually another topic that we're going to get to in just a minute, conflict of interest, but thank you for bringing that issue up. Anyone else who wants to be heard on the issue of guardian's relationship with other professional service providers? Okay, all right, then we're going to move on to standards for decision making. Is there anyone who would like to be heard on that topic? Okay. Seeing no takers, I'm going to move on to Mr. Franks. You want to make that on?
Mr. Franks, representing Ernestine Franks. As far as decision making, there is the ward is supposed to have their wishes granted if they're reasonable. Again, in my mom's case, she has expressed that she wants to do things. She wants the boys to spend the night. And again, the answer is, if you want to do that, go to court. And we're going to use your money to beat you down, and we'll make sure that you do not get to see your mother and spend the night and do anything she wants. Again, it seems reasonable that you would listen to somebody's and get them reevaluated also. But again, these are things that, this is not in the best interest of some of the guardians that need to keep these people as chattel. And that's, again, I'll use these terms, but I've seen it and many others have seen it. So we're talking about the bad people. Some of these guardians that have done things that are just not as reprehensible as what they are.
Well, thank you, Mr. Franks. All right, so we're just going to go ahead and now move on to confidentiality. If anyone wants to weigh in on the issue of confidentiality as it pertains to wards and professional guardians, please do so. Yes, sir.
Alan Saylor, St. Petersburg. I think this is going to be a very interesting one. That's going to be an interesting thing to deal with, because obviously certain things should be confidential, but it shouldn't be also an avenue where a guardian can try and hide some of the things that are going on. So I'd say that y'all probably need to make sure you spend a lot of attention on this, and those that need to be confidential, those issues can stay confidential. Those that the guardian might try and hide behind are out in the open, transparency on the proper things.
All right, well, thank you for mentioning that. We'll definitely keep that in mind. Mr. Franks?
Again, Doug Franks, representing Ernestine Franks. In our case, we had to petition the courts to allow us to be able to see receipts that we asked for. What we did find out was that there were shopping trips from 6 to 8 a.m. down on the caregiver's notes that there are no receipts for. Zero. So this is money being charged to my mom, but there's no evidence for it. Other meals, we got all these McDonald's almost every day, Heart Healthy Diet, but all these other different places my mom went. We couldn't get these things, and again, we need to protect the ward. We don't need to give out these receipts. We don't need anybody to know what she's eating. Well, of course you do. She gained 30 pounds, there was some problems, and this is an example where they're trying to hide something. But again, we brought this all to the court. Judge asked the attorney, is this typical for the ward to pay for meals, a totally incapacitated person to pay for the meals for the care workers? And the Bill Bonds, PensacolaLaw.com, McDonald Fleming Moorhead, said, yes, I believe it is, Your Honor. That's not true. That's absolutely true, and that's taking advantage of someone that's totally incapacitated. Again, I would think a crime, but it just continues to go.
Okay. All right. Thank you, Mr. Franks. Anyone else want to weigh in on the issue of confidentiality? Okay. So now we're going to move on to the, it's kind of a related matter, but decision making in regards to medical treatment. So specifically pertaining to medical treatment. Is there anyone who wants to discuss that issue? Yes, ma'am.
I'm sorry. Lynn Saylor. I was my mother's healthcare surrogate under guardianship from 2005 to 2010, and without any kind of proper notification. The last guardian, I was told that my healthcare surrogate was no longer good. He didn't really care to talk to me. He didn't want to know anything that had been going on or what was happening. And the guardian just prior to him totally did not even understand what a healthcare surrogate was. She had no clue. Every time I took my mom to the doctor, she was there trying to argue that she had power over my healthcare surrogate. And the doctors would come out, call their attorneys, and it was a big ordeal in the office. And then they would let me come in with my mother. And then she would come in afterwards and try to influence him to do something, is what he told me she did. And then my mother had to pay for her time. My mother was covered under Medicare and TRICARE, but she had to pay for the guardian's time to come in and try to argue with the doctor about what he wanted, what she wanted to happen, when the doctor had seen my mother for 15 years, and that was his decision. So they don't seem to understand what a healthcare surrogate is and how to cooperate with them.
Okay. Anyone else? Mr. Franks?
Doug Franks, representing Ernestine Franks, Pensacola, Florida. I had healthcare surrogate, and you have to have a separate trial to remove that if you know about it. If you don't know about it, 40 days pass, too bad, you don't have it anymore. That's what happened to me. My mother has gone in one time to be evaluated, but not for capacity. That was made clear by Belinda DeCozen with McDonald Fleming Moorhead. Cannot be for capacity. Why would you go in to get evaluated? Even in the notes, the doctor states that, Ms. Franks, you need to pick a power of attorney, because in a year or so, you won't be able to make that decision. Again, these are medical treatments being evaluated that simply is not in the best interest of some of the guardians. It is in the best interest to make sure this person is medicated and does not get any type of partial capacity. What a horrible term. They need to be fully incapacitated, not partially incapacitated, because partially means they have a say-so. And this is what I find, again, in our case and in many others, a problem. So I would say the evaluation process and the people, and that goes under medical, is very critical and very important. And these people need to be given the right to be able to get re-evaluated. And they also need to have training, so if they can have a capacity through mental games or other stimulation, that should be offered. But again, there's many different studies that show that doesn't ever happen. There is no, they can sit at the chair, watch the TV, and let the caregiver talk on the phone all day. That's ideal.
Okay. All right, anyone else want to be heard on the issue of decision-making regarding medical treatment? Okay. So now we're gonna move on to the topic of conflicts of interest. And we already briefly discussed this issue, but if someone would like to weigh in on that subject of conflict of interest, please let me know.
Julie London, Sarasota.
Is there someone on the phone? So actually, I think what we're going to do is to kind of help facilitate the process of the rule workshop. We're going to hold off on comments from the phone until towards the end of the rule workshop, because otherwise we have people talking over each other. But did you guys do that? Yeah.
I have a Doug Franks, Ernestine Franks.
Presentation mode is now disabled.
Doug Franks, Ernestine Franks, Pensacola, Florida. A litigation nightmare.
I would like to be heard.
That was weird.
That's a term that's been used before, litigation nightmare.
Presentation mode is now enabled.
If you're a lawyer, that is the sweetest phrase you've ever heard. And when the guardians select an attorney, some attorneys can actually, again, use stage litigation to drain the trust. We have so many different ones, and the more you fight, the more you go to court. And the more the ward's money is drained, so the quicker they're going to be out of their house or go into a public facility at some point in time, and it's all gone. And then from what my understanding is, once the money's depleted, hey, you Franks boys, hey, you other children, you need to take care of your mom. You need to be good children. Because the money's gone, no one's going to take care of them for free, and they want to have the children come up and take care of them. So there's a conflict of interest with not having the due process that we need to have to be able to stop this litigation going, which just generates money and drains the trust.
Okay. All right, well, thank you. Anyone else want to weigh in on the issue of conflict of interest? Okay, all right, we're going to move on to the next topic, and that's property management. Does anyone want to discuss that issue? Property management?
I guess I will. Lynn Saylor, my mother had two trusts worth of about $2 million. She owned her home free and clear, her car free and clear. She had no bills outstanding. When it came time for the last guardian, he moved. I had to take her to the emergency room because he refused to take her to a doctor. I took her to the emergency room because that was the only way I could get her medical help. She stayed there for 10 days. Then he moved her to a rehab center, which she was dehydrated. I don't know how you rehab that, but anyway. Yeah, I'm getting into the property management. Then he moved her secretly behind our back, 45 minutes away from our home. Then after she was there for a short period of time, she ended up staying 17 days in Warren Plant Hospital in ICU with 7 units of blood. But he called in hospice and told us that she was going to die within 6 months, and there was no way. It was a ulcer that lacerated because of medicine she was being given. But within about a year and a half of her being there, he said she could not ambulate anymore and got a doctor to sign that. So he would have to sell her home. He moved out all her belongings before he had permission from the judge to even sell her home. And he moved all of her belongings out of her home, put them in storage, did whatever. Then went to the judge, got permission to sell the house. He sold it in October. This is 2 years after calling in hospice. She died December 8th, and we were not even aware. She was walking. She would walk with assistance. She knew who her family was. So I don't know property management. He used to use the house. He moved her way up there, far away from her home and her family, but he would drive weekly to her home in St. Pete and charge for driving time just to flush the toilet, I guess, and look at it. Then for about a year and a half, then he drove back to his house. Then the next week he would drive back to her house, check it out, say family homeowner's check, charge her for his time to drive there, an hour there, an hour home. He gets $90 an hour. And then bill her through her home. And then she could have lived in her home with help. She had plenty of money to afford that. And she was pleasant. There was no reason for her not to be able to live in her home. But he chose not to let her live there for whatever reason. I'd love to hear that. But property management, he used my mother's property as a tool to make plenty of money for himself. He moved stuff without permission from a judge. He sold her house, was one of the nicest, was a nice house in the neighborhood, lowest price house in the neighborhood.
All right, well, anyone else want to weigh on the issue of property management?
Doug Franks, Ernestine Franks, Pensacola, Florida. And my mother lives in her house in Pensacola, Florida. And she actually has a lawn maintenance that they pay, and they mow dirt. Half the front yard's dirt. And court ordered, we're not allowed to take a picture of it. Which again, kind of strange, isn't it? These are things that, again, are being hidden so that the public doesn't know. She has a pool. People would put water in it. The caregivers are there 24/7. They won't put water, the motor burned up. There's many other things that happen. They pay a cleaning service to come in or they pay the people that work there that were a cleaning service extra money. They pay them overtime. Again, this is all to do with, in my mom's case and in many other cases, the ward's home. They just, how much more money can we squeeze? How much can we get out of this? Let's maximize the money. And as a trust manager for my mother's trust that recommended a third-party guardian, Roger Brown with Synovus Bank, stated, Ms. Franks, yeah, she has the money. She had the money. She had the money. She's about $1.5 million down now in less than 4 years. So it's been going pretty fast.
Okay. All right, that leads us to our last topic in regards to standards of practice, and it's somewhat related to the issue of guardianship service fees. So this is might be something people want to weigh in on, but if anyone wants to discuss guardianship service fees.
Sorry, one question. Do you mean the fees that they get for providing this
Yes.
service?
Mm-hmm. Exactly.
I think it needs to be reevaluated and looked at, and they should be compensated for, just like anybody with a certificate and what the job they're actually providing.
Doug Franks, Ernestine Franks, Pensacola, Florida. We recently had a new guardian assigned. The old guardian had enough. They wanted to quit, so they did quit. But they did handpick the new successor guardian. No doubt about it. We have the invoice that shows that they were talking months before the new guardianship took place, or was even offered on the table. The new guardian, he charges $250 an hour. Wow. I thought it was about 80 or 85, but he charges $250, Alan Core. So, you know, who's worried about that? I don't think anybody is. The family is, but again, we have no voice. And this is where we have to say, these people cannot get paid excessive amounts of money. You know, what are they really doing? If you're driving someone to the hospital, should you get paid attorney's fees? I guess is the question. And this is a real problem that we see.
Anyone else want to weigh in on that topic? Okay, so now we're going to move to a slightly different topic, which is the other real main thing that we have to do through rulemaking, which is to establish disciplinary guidelines for professional guardians when they violate the standards of practice that we're working on developing. And so, as I mentioned earlier, at some point we're going to actually publish in our notice of proposed rule a copy of our proposed disciplinary guidelines. But if anyone wants to weigh in on that, and basically to explain what disciplinary guidelines are, is they're essentially what they would do is they would be a range of discipline that would correspond to a certain act or misconduct. So obviously, the more serious the misconduct, the more serious the disciplinary action would be. But if anyone wants to weigh in just generally on disciplinary guidelines, you know, we'd be happy to receive your comments now. Yes.
Alan Saylor, St. Petersburg. I assume that basically that under this new thing, the Department of Elder Affairs will be licensing all professional guardians.
It's not technically a license. What it is a registration, but what would happen is that it would stay much the way it is currently. There's certain standards that you have to meet in order to be registered. Namely, you have to take a course, you have to pass a test, you have to pay a registration fee, you have to post a bond, and once you meet those requirements, you can be registered as a professional guardian. And then once these new standards of practice are in place that we're working on developing, they would be required, once they are registered, to meet those standards of practice. And if they don't meet them, what would happen is that there'd be various forms of disciplinary action that can be taken against them, and the ultimate sanction would be to take them off the registry. And if they're no longer registered, then they can no longer serve as a professional guardian. So it's not technically a license, but it's very similar.
Thank you for that clarification.
Doug Franks, Ernestine Franks, Pensacola, Florida. So in other words, if these people did do some type of financial exploitation, and it was proven, the worst that could happen to them is you're going to lose your license.
From our perspective, that's the worst that can happen. But honestly, there's also, like, if they met, if they were engaging in criminal conduct, they could also be referred to, like, the state attorney's office and that sort of thing for criminal prosecution. But from the perspective of the Office of Public and Professional Guardians, really the greatest sanction that we could take against them would be to remove them from the registry, and then they can no longer serve as a guardian going forward.
All right, I'd like to give you a good example of something. Back in 2013, December 31st, I got a telephone call from my lawyer. She said that Bill Eddings, the state's attorney in Escambia County, District 1, said Doug Franks is going to be arrested for making a false report to Adult Protective Services. That scared me pretty bad. And the attorney said, you're going to get a little postcard in the mail to turn yourself in. So this was under an investigation that Adult Protective Services did, and they had talked to the guardians, caregivers, and determined that Mr. Franks had lied. In February, I did talk at a Senate subcommittee meeting and voiced some of my concerns, and then around April, we got to get those invoices. We got to get all the meals that my mom was eating. And during APS's investigation, a 92-year-old woman was eating out and grocery shopping $1,000 a month. Doesn't happen. It's ridiculous. These people were buying food for themselves, groceries for themselves. 36 receipts are missing. All sorts of things criminal. But APS, I even went to them in Escambia County and said, wait, look at this new evidence. Oh, the case is closed. You know, we can't have that. We got to have, hey, wow, these criminal activities, or this, we have to refer it to the state's attorney or to law enforcement so they get a notice in the mail that they're going to get arrested. Right now it doesn't work that way. It works through intimidation, and this is what happens to all these family members. I mean, I would come to Florida, and every time I came, am I going to get arrested this time? Who needs to have that on their back? And oh, by the way, my mom's spending $100 an hour to see me, and I only can see her for 3 hours, and they can cut that off at any time. And currently, we have Pensacola Police Department, the supervisors with bulletproof vests, with weapons. They're in plain clothes, but again, this is the type of insanity that people are facing. You know, I've got my property, I want to keep it, I'll do anything I can. And what your department must do is they have to be honest and say, we're going to look at this, your proof, your facts that you have. We want to really look at them. And it's open, it's always open when you bring new evidence to us. And that's the only, because the judge, we gave it to the judge. Her answer was, we're not going to go there. I know where you're going, Jan Shackelford. I know where you're going, and we're not going there today. We'll never go there in court, in probate court. So again, this is where we need your department, where you can't do, you can refer it to someone that does have teeth for criminal activity.
Yeah.
And when people do this, they need to go to jail if they are found guilty. And then other people will not do this. But right now, you can do it all you want, and you will never get caught. What an incredible profession to be in.
Okay, well, thank you for your comments. Like I said, just so everyone's clear, the extent to which the Office of Public and Professional Guardians will be able to take action against a professional guardian, really the outermost limit of the disciplinary action that can be taken really is to take away their registration. But, you know, to the extent that we become aware of potentially criminal actions or misconduct, we certainly will refer that to the appropriate. So I think that's for it for disciplinary guidelines. At this point, unless there's someone else who wants to talk about them, at this point I'm going to open the floor to other matters that haven't been discussed. Is there some other matter that folks here at the hearing would like to discuss that we haven't previously gone over?
The callers on the phone.
Yeah, now that after everyone's had an opportunity to speak here, then we're going to open up to the people on the phone. So does anyone else in the room want to comment on anything?
Is there going to be an opportunity to comment later about what we filled in here, or is this the time
this is your opportunity right here, yeah. So anything else you want to talk about, and then we're going to open up to the phone.
Super. My name's Alan Saylor from St. Petersburg. I'd like to thank the Department of Elder Affairs for moving forward in creating this complaint department, which is Senator Dietert's comments on that. Creating this complaint department, which does not currently exist for guardians under the present system. And I'm very hopeful that the rules that are developed out of this are adequate to remove those guardians that are abusing those wards and their families under the current system. I would also hope that general members of the public are included in this process throughout the whole thing. And thank you for your time.
Okay. All right. Well, thank you. Mr. Franks?
Doug Franks, Pensacola, Florida, Ernestine Franks. Again, it's important that just the citizens of the state of Florida or concerned people with family members in the state of Florida do get to have a voice and get heard and are part of committee hearings or part of workshops, and their input is taken. Before closed doors, it's all private. We can't have that. We have to be involved. Again, there are Catherine Falk, Casey Kasem, Glenn Campbell, all these big names in Colorado and other states that are getting a lot of publicity. This is not just a Florida problem, but no one moves to Florida that's poor to retire. They moved down here, they got some money, and this is where the Sunshine State can be a dark state when people are unscrupulous and they take advantage of the elderly. Again, elder abuse is just as bad as child abuse. It is the same thing in my book, and it should be in everybody's book.
All right, thank you so much for your comments, Mr. Franks. Is anyone else in the room want to talk? Okay, I think at this point we're going to unmute the phone line. For those of you on the phone, if you could try to limit your comments to having one person at a time talk, because we don't want to have people talking over each other. It might be a little bit confusing in the beginning, but we're going to unmute the lines and we'll try to have one person at a time talk.
Presentation mode is now disabled.
This is Dr. Sugar.
Okay, Dr. Sugar, you can go ahead and make your comments.
Thank you very much. I appreciate the opportunity, and I express respect to the occasions that we're going to be seeing out after today. I've submitted written comments years ago, and I hope they'll be included in this minute. I wish to make it clear that I represent not just myself, but over 275 families with thousands of family members who are complaining loudly and particularly to be heard, particularly in the state of Florida.
That's good.
The state of Florida is running a corrupt and illegitimate court system. We are under attack by an organized group who profit greatly from the mistakes of others. Our group, American Justice for Probate Guardianship, wishes to have its voice heard not just today, but wishes to have the representation that is promised by Senator Disciplinary legislation, not just in creating the rules, but in effectuating the rules. We are concerned that we have lost our trust in government because of the abuse that we have observed and experienced in our individual cases. We are very hopeful and anxious to participate in the disciplinary procedure in addition to the rulemaking procedure going forward, and we feel strongly that just as Mr. Taylor and Mr. Frank have indicated today, their cases are not one-off. Their cases are not unique. Rather, they are representative of a playbook, of a system, of an organized racket that exists not only in Florida, but throughout the country. It is our opinion that this racket must be investigated, and if the state turns out to have a fiduciary responsibility for, like in California, the exact issue came up in California several years ago, and the result of that establishment of a disciplinary review board was that abuse increased dramatically. We pray that that should not be the case here in Florida. We pray that the public will be represented and that our group will be represented going forward, and that we will have a voice not only in creating the rules, but in taking in complaints and referring them to you with established evidence so that, at the very least, the administrative restraints that you are putting in place now will come into effect. But it is our hope, it is our fervent hope, that the guardians who have demonstrated that actually disregard for the law, and that the judges who work with them and the attorneys will be on notice that this can no longer go on. We are at war, and until the government recognizes these responsibilities to protect its citizens, the government has failed. I hope and pray that it will not be the case now. So thank you for this.
Okay, thank you for your comments, Dr. Sugar. Is there anyone
London,
else?
Sarasota.
What was your name, ma'am?
Julie London, Sarasota.
Okay. Would you like to make some comments?
Can everybody hear me?
Yes.
Yes.
Thank you so much. I wasn't sure how to work this, and I'm very sorry. Sorry that I don't quite understand how to do this. I guess what I want to say is one way to investigate these guardians who have multi-wards is if one person.
I love her. You look beautiful.
Excuse me, for those of you who are talking on the phone, if you can mute your line, that'd be great, so we don't have feedback. Okay, ma'am, you want to go ahead and keep talking?
Maybe I'm Sam. Nice to meet you.
I do Sam. I love it.
Do you?
You make the dance
Right now.
You make the dance
Is the room on a break?
No, the room's not on break.
Someone's phone is not muted.
Yes.
To mute their phone.
Yeah. Okay, ma'am, do you want to go ahead, from Sarasota, do you want to go ahead and keep speaking? I think maybe we've cleared things up now. Oh, wow. Okay.
That was Julie.
And all muted.
All right. Is there anyone else on the phone who would like to speak?
Yes, Beverly Newman from Bradenton.
Okay, ma'am, do you want to go ahead and give your comments then?
Yes, with respect to number one, the relationship with wards, the least restrictive environment, and making sure that whenever possible, the wards live at home and are not restricted from their families. I think that the rules should require in writing that the guardians specify if the ward is to be moved out of the home, why, exactly why. Not just standard language, but specific to that particular ward. If the ward is to be separated or restricted from family, then the guardian should have to put on the record exactly why, specific reasons. And also, with respect to religious rights. My father was a Jewish Holocaust survivor, and his religious rights were completely stripped from him while he was in guardianship of the person with a public guardian, who's also a professional guardian. They kind of go back and forth between the two. With respect to the service providers, we found out that the service providers were sending notes, constantly taking notes on the family, even after I had guardianship of my father. They were taking notes, or guardianship of the person, excuse me. They were taking notes and making up things like, Beverly does not allow peanut butter in the home. Well, that's ridiculous. I don't know why that would be important to begin with, but peanut butter is not prohibited in the home. With respect to the matter of transparent or confidentiality, excuse me. My father literally was hidden. We didn't know where he was for weeks. His car was hidden literally for months. Even after I became guardian of the person of my father, we didn't know where his car was. The guardian would not tell us. So, and there were all kinds of assets that were hidden in the final accounting. There were 4 cash value insurance policies that my father had on various members of the family that should have been cashed in for his care because the guardian just stopped all care. And my husband and I took care of my dad 24 hours a day, which thank God we were able to do, but that is not the case with every family. So the guardian hid these assets. They never once showed up on any accounting. The guardian also hid, scores of thousands of dollars in jewelry and claimed, even for the ones that were listed, which were very few, that those were lost. No repercussions whatsoever. So in terms of transparency, there were all kinds of very important matters hidden not only from the family but also from the court, and the repercussions, which should have been criminal obviously for conversion and exploitation of a vulnerable elder, the repercussions to the guardian were none, and to the attorney for the guardian. With respect to medical treatment, this is incredibly important. My father was so over-medicated that he absolutely 89 years old, an 89-year-old Holocaust survivor, which triggered very much post-traumatic stress disorder. So that needs to be addressed, and I have knowledge of many, many, many cases in which the psychotropics and the narcotics are administered like candy to our elders, which they do not need to begin with, and certainly not to the extent that they are being administered, and many times off-label. We have to realize that these are being used on elders off-label. And the Baker Act. My father was put into lockdown in the Baker Act for 3 weeks, not 3 days, 3 weeks. No hearing and no findings, just keep him hidden in the Baker Act, and that was extraordinarily detrimental to his health, his mental and his physical health. In addition to that, there was a no contact order. So we weren't even allowed to see him, call him, send him any kind of presents, etc. And it clearly states on the no contact order notes that the actual note from the hospital that this is what the guardian wanted. The guardian wanted my father in the Baker Act and my father to have a no contact order for 3 weeks. That was devastating and highly illegal. With respect to conflict, hiding assets, scores of thousands of dollars of jewelry and insurance policies that never showed up anyway. And the court didn't know about them as well. And liability. The guardian just decided he was not going to pay my father's taxes that he owed to the IRS. So to this day, 6 years after my father passed away, 6 years after my father passed away, there are IRS liens on both of his real properties because the guardian took every bit, every cent of the money for paying himself and paying the attorney. So that's a huge conflict of interest. When the IRS is owed money, it's also tax fraud. Again, no consequences to the guardian and the attorneys, all of whom knew this, that the taxes weren't being paid. With respect to property management, again, the property just disappeared. It absolutely disappeared. We didn't know where it was. And the taxes, again, were not paid. And with respect to guardianship service and fees, every time the guardian is involved in something, it invariably involves the attorney and then another attorney possibly and the attorney's staff, etc. So if you just want something as simple as transferring insurance, when we finally did get the car returned, then the insurance company was more than happy just to transfer the coverage so that my father's name would be taken off as a driver because he could not drive under the law, and I would be added in order to take him to different appointments, etc. The guardian was not allowed, so we spent thousands of dollars on a car that was worth $250 in order to have that car transferred, which I did not want.
Okay. All right. Thank you, ma'am, for your comments. We'll certainly take all those under consideration as we go forward with the rulemaking. Is there anyone else on the phone who'd like to be heard?
Yes, this is Amanda Haystack. I'm Director of Litigation with Disability Rights Florida.
Okay.
And I want to thank the department for their time in this important work, and I apologize if it sounds loud in here. I am actually driving today. and we would be happy to submit written comments as well.
Okay, great.
Based on the things that I've heard and the things that I know in our work in guardianship, we have found that oftentimes the petitioner and the ultimate guardian that is appointed, the professional guardian that's appointed, there's usually a relationship between the two before the petition even starts. And sometimes in that relationship, the notion of due process gets lost, and some people aren't provided due process. We would like the department to incorporate some look back kind of thing, to look back as to whether or not the guardian was involved in the original initiating petition, and whether or not there was actual due process provided to the individual. Secondly, we are always in favor of the least restrictive alternative, and that means that guardianship is a last resort. And we'd like to see some things where, in terms of that, that means once somebody actually is appointed a guardian, if that is the last resort someone needs to be doing so, substituted decision-making should be taken over. And the guardians, I believe it's the National Guardianship Association, has standard practices that we'd like to point the department to as far as incorporating those premises and concepts into their rules. And making sure that the guardian not only maintains the family relationships, but fixes and enhances those family relationships. It appears from some of the comments that I've heard so far that oftentimes those family relationships they might have been bent or somewhat fray at the time of the initiation of the guardianship, and then the guardian ultimately destroys those family relationships. So we want to make sure that that doesn't happen. And I have some other comments in regards to conflict of interest, but I think I'm going to resort to writing up our comments in terms of those things,
Okay.
possibly providing some scenarios that we've seen in hypotheticals, etc. And thank you very much for your time.
Okay, thank you. Is there anyone else on the phone who'd like to be heard?
Kathleen Zagaris, Tampa, Florida.
Okay.
Sir, I have a sad distinction of having two of my family members in guardianship, both of whom have been and are being abused. And the problem is we have no recourse or relief except to go to courts. We're forced to pay attorney's fees and we don't get help or justice. It is met with intimidation and retaliation against us having any time or having our relatives moved further and further away from us. No charges are ever filed or brought against the guardians. They aren't removed. I was in court not too long ago, and the magistrate said to me I had quite a lot of evidence against this guardian for neglect and abuse, for moving my sister to 5 different ALFs in less than 2 years, for over-medicating her, not getting her proper medical care. I could go on and on the things that she has done to try to keep me away from my sister. And I was told by the magistrate that the guardian was on the court registry and that she had more weight with the court because she had had a background check, and that they were not doctors, so they didn't really want to believe what I had, even though I had medical evidence, and they refused to remove her. My mother, who used to be a doctor, who has Alzheimer's now, was extremely abused in her own home for over a year. She suffered from vaginal abscesses, cuts, bruises. She had bed sores. No one ever saw anything wrong. DCF wouldn't do anything about it. The guardian, my mother was living in her own home, but she had many people from an agency abusing her because who's gonna do anything about it? And it took me a very long time, my mother was tortured in her own home. Within 3 years' time, she lost over $1 million and was pretty much all she had left was her pension and not much money left. And the guardian said that if I wanted any of the family valuables, I would have to buy them back from her because now my mother needed the money. When my mother was in her home, I used to take my mother to church, and I used to be able to visit her and see her and provide for her, or just try to be her daughter. And I was only allowed to go to one room of the house. They started putting my mother to bed at 5 at night, so that I couldn't stay long. The restrictions got worse and worse and worse. Finally, they stole my mother's house, everything in it, most of it was trashed. They have their own, the guardians have their own networks of private agency, home health care aides, real estate people, funeral directors. They have estate sales, and a lot of them have their own shops where they funnel these wards things into their own stores so they can sell them and keep the money. I don't know that you're aware of all these things. It's very, very big business. My mother had long-term care insurance, yet the judge said she had to spend down all of her money before she could go to an ALF where she would be more safe rather than being tortured in her own home. So when she got to the ALF, the only thing the guardian let her have in her room was some plastic, some stupid thing from Walmart that had plastic drawers, a bed, and a chair. That was it. She also hired her own granddaughter to take care of my mother in this ALF as a CNA. She hired her own granddaughter and paid her out of my mother's money. And when I would go to visit my mother in the ALF thinking, now I finally have some freedom, my mother will be safe, I was followed around by her grandmother, who said that she had to monitor me as per the orders of her mother, her grandmother, the guardian. I have been through hell, sir. My mother and my sister have been through hell, and there's just no reason why we have to use court as some sort of mechanism for justice when there is no justice. I would like to see when you get some panel of members that can investigate certain guardians who are just in this because they're sadists and greedy people. They're not good people. There's many of them that probably are, but I know 2 of them that I know aren't. And I would like to see a panel of members that include at least 2 people who are not attorneys or guardians. We need people like ombudsmen or social workers or psychologists or doctors on these panels to help make the proper investigation and get rid of these people. They're a cancer, and they should go to jail. These are criminal charges that they're committing against society, and none of us are safe. No one is safe. But I would like to see term limits on any of the panels of people who enforce the rules. I think they should only be there for 2 years. I think you should recycle members in the OPPG so there's no power or favoritism. And I think we all need to work together to understand that we're not all making this up. We all have proof and evidence, sir. Thank you for your time.
Okay, thank you for your comments, ma'am. Is there anyone else on the phone who'd like to speak?
Yes, Kathleen Dunn, Seminole, Florida. Can you hear me?
Yes.
A lot of the guardians are not taking care of their wards properly medically. A lot of people aren't getting their teeth taken care of. My mother went in the hospital, Jacqueline Scott, November 2013 for infectious bacteria. The nurses asked the guardian what is being done with my mother's teeth, and she said they were going to be taken care of when she got out of the hospital. They never were. My mother passed away August 19th last year. Her teeth were never taken care of. They rotted out of her head, broken one by one. My mother couldn't eat properly because the guardian let my mother's teeth fall out. My mother was able to go to the dentist. She wanted to go. I told her when she got out of guardianship, she would be going there first thing. But no, my mother was left basically to die. She was restricted visits. She never got to go anywhere for 3.5 years, and she sat all day in a windowless room with no bed. These guardians need to be psychologically tested because no one that is a decent human being would do these things to anyone.
Okay. All right. Thank you, ma'am.
That's all I have to say on that subject, but I'm telling you, people are suffering. People are suffering. My mother begged me to take her out of there. And when I told her it was the guardian that wouldn't let her go anywhere or live with me, she said, I hate her and I want nothing to do with her. That was removal right there because it was a conflict of interest.
Okay, thank you very much for your comments, ma'am. We'll certainly keep those in mind as we go forward. Is there anyone else on the phone who'd like to speak?
Tina Davey, Florida.
Okay, ma'am. You can go ahead and make your comments.
I'm not going to repeat, even though it's all true of what I've heard. We went through that. My mother already passed away. I can verify just about every one of these complaints of these people. But I would like to say one thing. One of the first questions the guardian that was appointed by the judge asked them, how much is the trust worth? If that doesn't answer a lot of questions, I think it's pretty obvious. Thank you.
Okay, thank you for your comments, ma'am. Is there anyone else who'd like to speak?
Yes, Fernando Gutierrez, professional guardian, Clearwater.
Okay, sir, you can go ahead and make your comments.
Specifically, NG standard, I believe it's 1415, guardian making medical decisions. Specifically, when we talk about end-of-life decisions, I believe there should be some standard where the guardian would have to request a second opinion, specifically not a physician in the same group that's the attending physician, and probably seek out an ethics committee like NGA standards mentioned, either hospital or private sector ethics committee to make those decisions. The fact is that most guardians have no medical training, and when they're making these important life and death situations, it should be clear, and they should have at least a second opinion before they render any decisions to end life support. That's all I have.
Okay, thank you, sir, for your comments. Is there anyone else on the phone who'd like to be heard?
Yes, Beverly Newman again. I had one more point.
Okay.
I think that crimes in the rules must be reported to law enforcement. That when fellow guardians or anyone else, service providers, are aware of crimes being committed, that those crimes must be reported to law enforcement.
Okay, thank you, ma'am, for your comments. Is there anyone else?
I have a comment.
Okay, sir. What's your name?
Hello.
What's your name,
This is
sir?
Robert Furtick, a guardian.
Okay.
Can you hear me?
Yes.
Okay. I have to move. First of all, we should say something that's positive about guardianship, because without guardianship, elderly people would be in desperate situation, would be out on the street. So let's focus a little bit on the positive. But at the same time, I had to move 2 wards from a facility that was terrible. I won't name the facility. My ward was getting urinary tract infections, for example, was hit by another ward. And so I moved them, but it was difficult to move them because I had to find another facility that would take them because they were on Medicaid, Medicare. So facilities should be investigated for their quality of control. I know OPPG is supposed to do that. But we have to go there unannounced and check out these facilities. Too many people are lying in the halls or in their rooms just watching television, staring out a window. This is true. So guardianship should be more proactive about taking care of the wards, especially their medical care, as Fernando just stated. Thank you very much.
All right, thank you for your comments, sir. Is there anyone else who'd like to be heard? Okay. All right, at this point then...
hello?
Yes, ma'am. Would you like to make
Hi,
comments?
this is Lynn Marie Boltsy. I'm a professional guardian as well in Pinellas County. And I just wanted to add on the comments that are made by other people. I'm very sorry for the situations that they're in. I too will follow up with Robert. There is so much positive work done by guardians. And I know the committee knows that, but I felt compelled just to pick up the phone and unmute it to say the work that's done by guardians, the pro bono work, it's just not known out there how much is done. I personally know Fernando and Robert. I know Fernando's done a lot of pro bono, myself, and many other guardians. So we want the people that feel that they have been hurt by the system or hurt by a particular guardian to remember that there are a lot of really good guardians out there. I thank you for putting this committee together and this call today. I think it's imperative that we do have some rules and more oversight. But I also want to ask some of the family members, and this is a real touchy point for me, so many family members get upset that a guardian's appointed, and it makes me have to ask, why aren't the family members appointed? What was the reason why the family member was not appointed as guardian? And in a lot of cases, the family member doesn't see themselves what might be some issues. So we'll hang up on a positive note just saying there are many guardians throughout the country that do lots of pro bono, and I personally am really proud of the work they do. If they're doing something wrong, then they all should be found guilty, and whatever law enforcement and you all can assess to them, I think that's what we need. Again, thank you for the call today.
Okay, thank you, ma'am. So at this point, I'm going to move into my concluding remarks. I just want to let everyone know that the presentations that were made here today will be given careful consideration. The record for this rule workshop will be held open for a period of 7 days for people to give written comments. So if anyone wants to submit written comments, they can email them to me. My email address is nelsonj@elderaffairs.org. Once again, that's nelsonj@elderaffairs.org. And I want to let you know that the department intends to continue on with this rulemaking process without any unnecessary delay. And under the Administrative Procedures Act, the rulemaking process requires a lot of preparation and creation of documents and considerable work, but we're going to continue on with that process as expeditiously as possible. And finally, I just want to let you know also, once the rule is finally ready to be adopted, there is a statutory waiting period before it becomes effective. So at this point, if there's no further comments, I'm going to declare this rule workshop to be adjourned. Thank you.